Welcome to the public hearing before the Inter-American Court of Human Rights. The case is Gonzalez Méndez versus Mexico. Today is May 15 of 2025 and our location is the courtroom of the Inter-American Court in San Jose, Costa Rica. With the quorum of 5 judges duly established, we declare this hearing open in the case of Gonzalez Méndez versus Mexico. The parties will present their arguments in the following order. First, the Commission, then the State, followed by the replies and final observations. Honorable judges, we come before you to demonstrate the State of Mexico international responsibility for the forced disappearance of Antonio Gonzalez Méndez on January 18, 1999 in violation of Articles 5, 8, and 25 of the American Convention of Human Rights, as well as the Inter-American Convention of Forced Disappearance of Persons. First, the disappearance occurred in a context of militarization and by armed activity by groups tolerated or supported by the state. Second, there was a complete failure to investigate. No essential procedures were undertaken, key witnesses were not interviewed, and physical evidence was not preserved. Third, this case is part of a broader pattern of abuses against individuals linked to the ESLN. For this, we respectfully request the court to 1. Declare the international responsibility of the State of Mexico. 2. Order full reparation for Antonio's family. And 3. Impose guarantees of non-repetition and institutional reforms. Could you clarify which specific procedural actions were omitted? There was no field search in Ocosingo, and no military reports were requested, no forensic investigation was conducted, and the local communities were never interviewed. Honorable judges, Mexico firmly denies any direct responsibility. There is no conclusive evidence that links state agents to the alleged disappearance. Nevertheless, we deeply regret the disappearance and affirm our commitment to the truth and justice. Since the early 20s, we have strengthened our legal framework, first with the General Law on Forced Disappearance in 2017, and then in 2018, the creation of National Search Commission. Your Honor, initial investigations were indeed conducted in Chiapas. These investigations include witness interviews and local inquiries, so also the armed conflict context complicates the attribution of responsibility, and these acts may have been committed by non-state actors. Can you provide any documentation of actions taken between the 1999 and 25 regarding the investigation? Yes, Your Honor. We have submitted official request by the Ocosingo Public Prosecutor's Office from March and April 1999, including statements by the victim's spouse and some neighbors. Those official requests that you mentioned had no follow-up, and there were no field visits, no forensic procedures, and no military inquiries. The Commission had to understand that the lack of monitoring reflects the institutional limitations of that period, not deliberate negligence or state policy. With this, we reaffirm that Mexico failed to meet its due diligence obligation and violated Article 1.1 of the Convention by not preventing or investigating the disappearance effectively. Thank you to both parties. The court will proceed to deliberate and issue a judgment in due course. The hearing is now adjourned.